Good morning, everybody. Welcome to Law Minds. So, today we'll be talking about the topic power of attorney and its revocation. So, first, let's begin by understanding what is a power of attorney. So, a power of attorney is basically something that it is basically a legal document. Okay, it is a legal document that allows a principal to designate an agent to act on the principal's behalf in specific situations. So, and it was first defined by here Power of Attorney Act 1882. All right. Okay, so when principal is unable to execute a document or himself or herself or anything, so then the power given, that is power of attorney, to act on behalf of the principal. Okay, so there are basically two types of power of attorneys: general and specific. So in general power of attorney, it is basically where the agent is authorized to act on behalf of the principal in any situation, okay, where it is permissible by law. Okay, it should be lawful. All right. So now, for example, on behalf of the agent, on behalf of the principal, the agent may be able to acquire stocks, sell property, designate caretakers for assets, sign checks, maybe lease rent, lease real estate, okay, or maybe participate in court in any dispute. So basically, all this, if uh, it is given for all these things, then it is general power of attorney. Okay, so this was just an example, so a variety of things. Okay, now we talk about specific power of attorney. It is basically only done for certain kinds of things. So, for example, in specific power of attorney, a particular power of attorney can specify that the agent's only authority is to obtain rent. The agent cannot buy the house. The agent cannot sell the house or increase the rent or decrease the rent. You are only authorized to collect the rent. That's it. Okay. So that is what we are talking when we say specific power of attorney. Now there are two kinds. It could be revocable or it could be irrevocable. So when we're talking about revocable power of attorney, so most of the times it is revocable, but in certain circumstances it is not revocable. All right. So it is by virtue of Section 201 of the Indian Contract Act 1872. Now we'll see certain situations wherein the power of attorney can be revoked. Okay, so now, but it is important to understand that there are no guidelines. Okay, these are just the court's observations. All right, whatever the court has determined, these are those conditions, and there are no specific guidelines for rescinding power of attorney in India's legislation. Okay, governing contracts and power of attorney. All right, so the first one is the principal revokes. Okay, so through the principal's acts, then it could be uh, because of the agent loses their mental capacity. Okay, the agent becomes bankrupt, insolvent, adjudicated by the court. Okay, and or if the power of attorney holder renounces. Okay, if the holder says that no, I don't want it anymore. Okay, so then the principal can revoke, or if the business is completed. All right, if whatever जिसके लिए भी दी गई थी power of attorney, that work is completed for whatever reason, the power of attorney was given, the work has been finished, so that's when the power of attorney can be revoked. Okay, now we'll talk about irrevocable power of attorney. So it is okay, so it is important to note that it is not irrevocable merely because it is stated in the clauses of the deed. Okay, so if the agent has a stake in the power of attorney's subject matter, the agent must agree before the power of attorney may be cancelled. Okay, so according to section 202 of the Indian Contract Act, the principal is not permitted to revoke a power of attorney if the agent has developed an interest in its subject matter, since doing so would be detrimental to the agent's interest. Okay, so that was section 202 of Indian Contract Act for you. All right, so important to keep this in mind when understanding the circumstances where it cannot be revoked. Okay, so now we'll talk about the procedure for cancellation of the power of attorney. So, a deed or notification of revocation of the power of attorney must be drafted by the principal, and the reason its effective date and any associated repercussions must all be included in the deed. All right. Then in order to, so this was the first step. Okay, the deed. Okay, so as I've mentioned, the deed or notification. All right, so it is has to be drafted by the principal and everything needs to be there. The reason why are you revoking the power of attorney, from when will it be, okay fine, let me just write it. The reason, the date, okay, from when will it be uh, affected, and the repercussions. Okay, all right, which all these must be included in the, okay, yes, so all these must be included in the deed or notification. Now, in order to proceed with the revocation procedure, the agent must receive a proper notice of the, so the principal has drafted this, but has the agent received? Okay, so first you need, the principal needs to make it, and then the agent, yeah, then it needs to be received by the agent. All right, we need to make sure, sorry, yeah, by the agent. Okay, so we need to make sure that the agent receives it. Then to notify those the agent is dealing with on behalf of the principal, the revocation must be announced in a local or national publication together with the deed or notice of revocation. So public notice through local newspaper. All right, so now the power of attorney deed must be registered by the same body that created the power of attorney. All right. All right, so that was that. Okay, so after the, after this newspaper part is complete, this local or national publication together. All right, so next comes that the power of attorney cancellation deed must be registered by the same body. Okay, it needs to be registered by the same body. So this we are talking about the cancellation deed. Okay, cancellation deed of the power of attorney must be registered with the same body that registered the power of attorney in the first place. Okay, that created the power of attorney. Now, to notify the agent of the registration of revocation, a copy of the power of attorney cancellation deed should be supplied. Okay, so, all right, a copy of the power of attorney cancellation deed needs to be supplied, okay, to the agent. Okay, to the agent. Now, to notify the public at large, so now you also need to notify the public. So then that the agent's authority has been withdrawn, so for that a printed publication of the power of attorney's registration cancellation deed is required. So so in all right, so to complete the responsibility for the that you owe towards the public, there needs to be a printed publication of the power of attorney's registered cancellation deed. Okay, a printed publication. Now it's so after all that, in order to end any business or interactions with the agent, copies of the power of attorney cancellation deed can also be delivered to anyone with whom the agent has been in contact on behalf of the principal. And then, when the principal or agent passes away, becomes insane or insolvent, or when the power of attorney's main objective is no longer met, then the power of attorney is immediately cancelled or revoked. Okay, so that's about it. That's the procedure, and that was it for the cancellation process. Okay, so thank you, everybody. Thank you for your kind attention, and please like, subscribe, and share this channel for more legal updates and such informative lectures. And thank you so much.